Hi, my name is Sonali Jain, and I'm a fourth year law student from School of Excellence in Law. I'm enraged about this issue as anybody else is, but before taking to social media, I feel like there are a few facts and circumstances that we must all be aware about. I'm just going to try to put them in an easier way and throw light on the points that I feel are relevant. Firstly, when we talk about what is the procedure for arrest and what are our rights, some basic things that we need to know is that A, the reason for which a person is being arrested must be communicated to the person being arrested at the time of arrest. 2, he must have the right to speak to a lawyer. And 3, according to section 167 of the Criminal Procedure Code, this person must be produced in front of a magistrate within 24 hours of this arrest. Let's tackle the question of whether an arrest was necessitated in this case. In this case, the reason that was given to the father, Jairaj, was that his shop was open beyond the curfew hours. This would only require either sealing of the shop or fining of the shop, which should have been the first or the only step that the police must have taken instead of arrest. And even though Jairaj was arrested, his son was not even at the shop at the time of the arrest. His son had visited the father in prison, and while checking up on him, he was arrested as well. So it is important to know that these are a few of our rights that we need to keep in mind. Secondly, when he was brought to before a magistrate, it is important to know that he was kept 10 to 50 feet away from the magistrate. So the magistrate could not physically examine him, but remanded him to custody anyway. So generally, a magistrate must physically examine him in the case and then give an order, which could be either a bail, or it could be remanding to police custody, or it could be remanding to the central jail. In this case, he was remanded to the sub jail, but without physically examining both of them. And the reason that was cited for this distance was social distancing, which cannot be taken as an excuse at this point of time because it's the matter of life or death. The second point that I would like to go over is what are the charges that he had been arrested for. The FIR stated that he was arrested for section 188, section 269, 294B, 353 and 506 part 2. These are offences such as disobedience of an order by a public servant, which is punishable by 1 month, a negligible act that spreads a disease, which is punishable by 6 months, reciting obscene language, which is punishable by 3 months, assault or criminal force that deters a public officer from doing his job, punishable for 2 years. And these are all bailable offences, and none of these offences are of grievous or heinous nature, and even if they were, custodial deaths and police brutality will still not be accepted. Section 49 of the Criminal Procedure Code says that no external or extraordinary force must be used, or any extra force must be used that is not necessary to prevent someone from fleeing custody. In this case, they were not trying to escape custody. So any unnecessary force that was used was above and beyond the powers that have been conferred on these police officers by any statute of law. Thirdly, I would like to speak about how all of us have taken to social media and we're sending mass emails to important people in the government and important personnel in the government demanding for action and demanding for justice. And I understand that the intention of it is good, but we need to recognize that the email that we are sending demands for justice or demands for action which has already been taken. The Madurai bench of the Madras High Court has taken suo motu cognizance of the case. Suo motu means by itself without a complaint being filed. So they have taken cognizance of this case and they have passed orders and have opened up an unbiased investigation on the police officers who were in the police station at that point of time. These 2 police officers in particular, the doctor that gave the fitness certificate and also the magistrate that remanded them back to custody. So these are the stakeholders that are going to be involved in this investigation. So it is important to note that the magistrate did remand them when both the accused were 10 to 50 meters away and there was no physical examination of both of them. And 2, a fitness certificate was provided with no timestamp on it, which clearly means that it could be bogus Or even if a fitness certificate was given, the point of a fitness certificate is to notice the injuries that have been on the body before the arrest and after the arrest, so they can pinpoint what are the injuries that are due to police custody. In this case, it is clear and obvious that the police went overboard and that this medical certificate, this fitness certificate is fake and has been done by police extortion or threatening the doctor, which is unacceptable. The last point that I would like to make is that we are asking for action that has already been taken. Instead, we can edit these emails and ask for something that will actually be of value, which is one, in 2006, the Supreme Court delivered a historic order where every state should have a police complaint authority that must be established to lodge misdemeanors committed by these police officers, which only a few states have established. So we can demand our state governments to establish this authority. We can demand that CCTV cameras must be made mandatory in all police stations. This will increase the evidence and is directly proportional to the amount of custodial deaths that will happen, inversely proportional once these CCTV cameras are installed. So these are some of the solutions that we can ask for. We can ask for training. We can ask for training of these police officers. We can ask them to be sensitized to the issues of police brutality. We can have trainings and briefing sessions about what a police officer is mandated and not mandated to do according to law. What acts are extrajudicial? What acts are allowed by the Criminal Procedure Code or any other statute for that matter? We can demand that our government signs the United Nations Convention against torture and inhuman treatment. We are one of the 9 countries that have not signed this convention yet. This is something we can demand for. Every custodial death is a reminder that we should. Lastly, that I would really like to highlight is that we are all saying suspension is not the right punishment. But it is important to know that suspension is only the first step after the investigation. Once these police officers are convicted of the crimes such as Section 302 for murder, Section 506 Part 2 for criminal intimidation, and Section 120B for criminal conspiracy, they will be punished according to the Indian Penal Code. They will be imprisoned for 7 years or more, or even life. These are the punishments that will be levied upon them once the trial is conducted and they are convicted of these crimes. Suspension is just a temporary thing that has been taken until the trial is over or until the investigation is completed. So we need to understand that the things that we are asking for through social media are things that have already been given to us. We have an unbiased investigation. We do have the judicial system that is taking this up, that have asked for an investigation with post-mortem reports, CCTV footage, with medical reports, with statements from every eyewitness. So steps have been taken. So when we do take to social media, we need to recognize what we are asking for. Let's know the facts and circumstances before we do something. And I hope that we keep fighting the good fight. And this is not a fight just for these two. This is a fight for all of those cases that have not been given the media attention that they deserve. There are hundreds and thousands of cases. This is the only one that has gotten the media attention. So let's use this as a stepping stone, and let's keep fighting for what is right.